Thank you for your invitation. We will do this lecture in a kind of collective way with Giulia Bruno, that is here on my left, Vincenzo Latronico on my right, and myself, Armin Linke. We would like to divide our presentation in two parts. In the first part, Vincenzo Latronico will speak specifically on the topic of multilingualism at the European Court of Justice. As we also have the installation that we present in this space, that is there, or when you enter on the right, or when you go out on the left. And this installation was made possible through Vincenzo's research, not only as a writer, but also as a translator, and his long-time interest on the topics of language. With Vincenzo, I had also the opportunity to make many different projects, and in particular a book where we traveled from Djibouti to Addis Ababa along the former Ethiopian railway. And his written narration traveled together with the visual photographic narration. And here we will make a similar experiment, presenting during Vincenzo's presentation a stream of images that we did with Giulia Bruno during the visit at the European Court of Justice in Luxembourg. We would like also to thank very much the whole communication team and also the translation and interpretation teams at the European Court of Justice in Luxembourg for the trust and for allowing us to spend several weeks observing their various working processes.
Hi. There's two main concerns that we have had with the visual essay that we will be showing some excerpts of here and that is visible there. And these two concerns are, first of all, when is translation visible? And the second is, what is the language of the European Union, if there is one, if the European Union also is something that is going to exist longer, but this is something that we'll only just briefly touch. So I would like to start from the two tallest skyscrapers in the country of Luxembourg rise on the Kirchberg Plateau, and they have been built a decade ago by the architect François Perrault. A third identical is on its way, the one with the black addition. From the distance, and they really look like that, they look like hard drives made of gold. Formally, they are the seat of the European Court of Justice, but actually they do not host the judges or the cabinets. They are the offices of the court's translation service, which also takes up two other buildings nearby. It has almost 2,000 employees, and it's the biggest translation service in the world. They are responsible for translating all of the court's rulings and proceedings into the EU's 24 languages, more than 1 million pages a year. They cover more than 500 combinations, Italian to Latvian, Maltese to Polish, Estonian to Portuguese. It is not only the largest translation center in the world, but it is so by a great margin. The UN has 6 official languages. The African Union has 4 official languages, only one of which is not of colonial origin. Europe has 24. And yet this center is completely, utterly invisible. Hardly any European citizen is aware that even that it exists. Paradoxically, this is because it works. Any European can deal with the EU in their own language, and hence they're unaware of how difficult and complex it is to make this happen. Successful translation and interpretation is a vanishing act. This is also visible in the interpreters, which I thank with all my heart, who are always kind of hidden in the dark, behind a one-way mirror. When translation is visible, when a text sounds translated or does not match the original, this is usually taken as a failure. I'm not talking about literary translation. Recently, it is becoming more theorized that literary translations should be visible and interfere, and this is fantastic. But 99% of translation is not literary translation. It is hundreds of thousands of people all around the world converting between languages, recipes and iPhone applications, instruction manuals, conferences, peace talks, textbooks, soap labels, and of course, laws. And the need for invisibility of translators is even more important when it comes to law, which has to apply consistently and equitably across the European Union in this case. A translation mistake would imply different rights and different obligations for different citizens of the European Union. This is not something that can be allowed to happen if we are to follow the principles of the EU. Translation at the EU has to be invisible if it is to function. But then, of course, from this perspective, translation, especially legal translation, perfectly fits the definition of reproductive labor. Nursing, cleaning, teaching, nurturing, feeding, taking care of. A labor that is seen as subordinate because not actually productive of anything, but as a mere support role to the actual production. Reproductive labor, think of unpaid house care or cleaning personnel working at night, often requires a diminishment of the laborer's identity and presence in order for it to seem as sleek and automatic as possible, as if happening by magic, by itself. Of course, this is a gendered perspective, since reproductive labor is usually carried out mostly by women, and this is true also of translation, and also of translation at the EU. As decades of feminist thought have made clear, though, reproductive labor is not improductive labor. What it produces is labor. There is no so-called productive labor. There is no one without the other. And this is in part why Giulia, Bruno, Armin, Linke, and myself were interested to shed light on this most massive and yet most invisible of European institutions. What we wanted to understand is, how does it work? What are the effects of its invisibility on its functioning? And ultimately, what does its reproductive labor produce?
So what is special about the work of an interpreter? So what makes it different from working with written texts? We always work in a simultaneous mode. So we go along as the speaker goes. So the speaker opens the microphone, says a couple of words, and then we kick in. So the most important thing, or the most important difference between translating and interpreting, is that we more or less only convey meaning. So for us, it is very important to have a piece of meaning before we can start interpreting. So we do not interpret single words. So I can only start opening the microphone or opening my mouth when I have already processed the information, or part of the information that comes in and makes meaning. So in a way, you never realize what language is spoken, because you don't listen to the level of signs, the level of language, because in your head it creates a picture, and then you only convey the pictures as they come along in your head, and you convey the meaning that are generated in you, or that you understand. This is a very important aspect. Now we are here at the court, and court interpretation also requires a great deal of precision. So here we have, in a way, the dilemma that we convey meaning, but we also have to convey and be words and be very precise, because sometimes in legal texts it's about this one word that makes all the difference.
So the German interpreter that was speaking was Katharina Gremper.
Now, I'll have to get a little bit technical to understand exactly what these translators do, because to understand what these translators do, we need to understand what the European Court of Justice does. And it's kind of a mess. So first of all, the linguistic policy of the European Union is that determined by what is so-called the principle of linguistic diversity. Every member country can determine one official language of its that will be adopted by the European Union as an official language. And in principle, every citizen has a right to address the European institutions and to get answers in their own language. This, of course, doesn't really happen because, as we know, it is even the case in Italy, this doesn't take into account minority languages, dialects, migrant communities. So it is already a pretty normative situation. But as far as normative goes, it is extremely lax and extremely multiplicitous compared to similar sovereign national situations in the past. And of course, this principle of linguistic representation or linguistic diversity is particularly relevant in legal matters. Of course, the EU does not issue laws proper. The European legal system, which has been made up as it went over the decades, is actually a meta-legal system. The EU issues directives or decisions that each member state has to translate both in their language and in their legal system, which often are very, very different. What the Court of Justice of the EU does, mostly, is operate at the request of national judges, so in all the member states, to rule whether some European directives apply to a specific case. I'll make an example because I realize that this is very abstract. So let's suppose, for example, that a company in Veneto, in Italy, in northern Italy, goes bankrupt and does not pay back wages to their workers. But the European Union has a regulation that says that governments have to have a fund that will pay unpaid wages to workers in case that companies go bankrupt. Only this European directive, so this is a right that every European citizen has not been turned into a law, translated into a law by the Italian government. So an Italian worker who has not been paid sues the government over it, saying, I as a European citizen have this right, but as an Italian citizen I don't. The Italian judge doesn't know how to proceed, because on the one hand, the worker's rights as a European citizen have been broken. On the other hand, the worker's rights as an Italian citizen have been respected. So how to deal with this kind of missed overlap? They refer to the European Court of Justice for a preliminary ruling. This is actually a real case. It's called the Frankovic case. It took place between the late 80s and the early 90s in Italy, and it resulted in one of the Europeans' landmark rulings, which states that countries are liable towards citizens if they suffer the effects of non-implementation of a directive. This might seem still very far removed and abstract, but actually the Frankovic case, and just that, is one of the reasons why many right-wing populist governments are so much against Europe in Europe. Because several European directives mandate equal opportunities and forbid discriminatory practices. As an Italian, I know that many discriminatory policies that the Italian government has actually been trying to implement have not been implemented just because they would have been blocked by this kind of mechanism. The Frankovic case, and many like that, could be heard by the European judges, which are 28, one from each nation, only because it had been translated into the 24 languages. Similarly, their ruling, which had originally been written in French, was translated into all the 24 European languages so that judges and lawyers all over Europe could reference it and apply it, even without knowing Italian or French. An interesting side note here is that even though rulings are originally written in a common language between the judges that they will find according to the situation, the authentic language of the procedure is the language where it originated from, in this case, Italy. Which means that even though the ruling has been written in French, the original is the Italian. So there is one translator at the European Court of Justice that actually produced an original by translating a translation. Yeah, this is what the law does. In this sense, though, turning back to the fact that all this application of these rights was only made possible by the fact that translators facilitated the exchange of information. In this sense, just as reproductive labor ensures the effectiveness and the existence itself of so-called productive labor, the invisible translation work carried out at the Court of Justice ensures equality over the Union as much as the rulings of the judges themselves.
This is Jean-Michel Rachet, head of the private office of the Chancellor.
Le multilinguisme, ça n'empêche pas l'adoption de langues communes pour se comprendre. Mais la langue commune, il y en a eu toujours dans l'histoire, elle ne doit pas empêcher l'existence des autres langues. Et c'est précisément ce qui se passe à la Cour. Parce que ce que nous construisons à la Cour, des auteurs célèbres l'écrivent, le disent, c'est un bien commun. C'est quelque chose de plus. Il y a des gens qui disent que le droit européen, c'est une langue supplémentaire. Tous les gens qui font du droit comprennent d'ailleurs, ou tous les gens qui approchent le droit, même dans leur propre langue, comprennent ou ne comprennent pas ce que dit ce droit et se disent que c'est probablement une langue supplémentaire et qu'il faudrait apprendre le droit. D'ailleurs, on va à l'université pour apprendre le droit, comme on va à l'université de médecine pour apprendre des termes qu'on n'emploie pas tous les jours quand on veut devenir médecin. Alors, je ne crois pas qu'il y ait un antagonisme réel entre le choix de langue commune pour se comprendre. Je vais voyager en Europe, je vais par exemple parler le globish pour pouvoir me faire comprendre, et c'est tout à fait parfait. Et c'est ce que disent aussi des grands académiciens dans beaucoup de nos universités, dans beaucoup d'États membres. Il n'y a pas de problème à avoir des langues communes. Mais cette langue commune, puisqu'elle est utile, elle est quand même réduite en termes littéraires, par exemple. Voyager, ce n'est pas écrire. Et il faut conserver sa propre langue pour pouvoir enrichir également la langue commune qu'on adoptera pour se comprendre. Donc je ne crois pas qu'il y ait d'antagonisme. Et pour ce qui est de la Cour de justice, évidemment, il faut donner la possibilité à tous les citoyens de s'adresser à la Cour dans leur propre langue, et il faut leur donner la possibilité de comprendre ce qu'écrit la Cour en droit de l'Union européenne dans leur propre langue. Si on leur imposait de le comprendre dans une langue commune, il n'y aurait pas de possibilité d'imprégnation de ce droit dans les États membres. En vérité, les gens parlent beaucoup d'identité, de manière ethnocentrique, et c'est ça qui est très dangereux. Alors que la langue, c'est quelque chose qui ouvre, qui enrichit, ce n'est pas une frontière. La langue, c'est une possibilité.
Historically, language is a crucial part of the construct of collective identity, which, of course, over the past centuries has been channeled by the device of the nation-state. We're going to turn back to that later. The assumed identity between a so-called people and a mass of land was guaranteed by the fact that theoretically that mass of land was homogeneous from a linguistic point of view. Of course, this stipulation was only possible by cancelling out or literally eradicating and exterminating dialects and indigenous languages, minorities and migrant communities. Also, the unification of several nations usually passed by the imposition of an official language. In the Roman and the Chinese Empire, for instance, but also in colonial invasions everywhere. From the church's Latin to colonized Ethiopia's Italian, the writing of laws in a language that the population did not understand has always been an instrument of domination. In the context of the Court of Justice of the European Union, the need to have its rulings understood across a multinational, multilingual territory is a basic principle of its foundation. Even more egalitarian endeavors than empires, such as the United Nations and the African Union, only recognize a handful of languages, prioritizing efficiency over concerns of access and equality. But of course, one could say the UN and the AU are organizations for international cooperation. They have little or almost no contact with citizens. Nobody, or almost nobody, would define their identity, whatever that is, with respect to the United Nations or the African Union. The European Union, even though it started only as a vehicle for facilitating commerce, has subsequently morphed, and it has become a kind of like multinational nation of sorts, or at least it strives to be. In order to do this, it had to decouple linguistic identity from political identity. Rather than exclusionary, the European language space had to become a place for intercommunication, a kind of commons. Of course, multilingualism was not the only way to make this happen. For instance, I am speaking to you in English, and it's kind of working out. It's neither my native language, nor, I guess, the native language of most of the non-native German speakers here, the German speakers being provided by the incredible services of interpreters. As everyone knows, around the visual arts, especially around culture in general, the international debate is more and more channeled through English, or, as Olga has called it before, Globish, or some variation of the two. It's been established as a kind of international lingua franca. This too could be a space for intercommunication. But of course, the reasons for the prominence of English is not that it makes a good lingua franca. It has to do with colonialism, it has to do with imperialism, it has to do with the developments of capitalism over the past century. And the effects are evident. In most countries, access to English training is a class-based privilege. In Italy, it is too. And these imbalances, these imbalances reverberate across the composition of exhibitions and panels and magazines and publishing catalogs. English is a language of power here too. And the role it plays in the international discourse around art is similar to the role that any language of empire has played upon its subject, be it Latin in the Roman Empire or Italian in Italy's short-lived and deadly colonial project in East Africa. In this context, the mastery of language is proportional to your closeness to power. And most nefariously, the effort required to learn a language is inversely proportional to your closeness to power. If communication among people for different countries is a commons, then the burden of the work required to make these commons happen lies disproportionately on the shoulders of the less privileged. The idea of a universal auxiliary language, such as Esperanto, has often been proposed as a solution. It does sound more democratic. Instead of picking one language such as English or having it imposed by political forces, an auxiliary language would be designed to be maximally simple and easy to learn as a second language for anyone. Nobody would be born into it as a kind of birthright. Under the example outlined before, if we see intercommunication as a commons, then in this case, the cost for it would be more evenly distributed among everyone. But still, one could argue that making the access to knowing your rights and duties, as is the case with law, subject to learning a language, is still too high a barrier. From this perspective, then, the invisible activity of the translators at the European Court of Justice could be seen as a concentration of all the distributed effort required to make the commons of multilingualism happen, to make 28 countries, or 27 in April, speaking 24 languages into a seamless community. A few thousand people taking on themselves the work that would otherwise be unevenly distributed across the population. The product of their reproductive labor, under this perspective, would be something as immaterial as a shared right, the decoupling of the linguistic and the political identity, a condition of possibility of Europe, whatever that is.
Law is a real problem to do in a multilingual and multicultural environment. There is no problem about being a mathematician and going to a different country with a different language. You learn about 20 words, you know, hello, goodbye, thank you, may I have coffee, and you can operate professionally because all you have to do is take a whiteboard and write equations. And the language is universal and your colleagues will understand you. Law is really at the other end of the spectrum because law is utterly crafted out of language. What we use to express concepts, what we use to make distinctions is language. And that means that managing to operate with 24 official languages of the European Union is an extraordinary challenge. And the whole work of the institutions in promulgating law, but above all for me working here, the work of the court in interpreting that law, turns on how to meet that challenge properly and effectively. Because also with the language, and I will try to stay mainly with language, but you must also understand that with language comes also our judicial culture, our different legal cultures of the different traditions, and with that also our own backgrounds as to how we expect language to be used among lawyers.
Umberto Eco famously claimed that the language of the United Europe is translation. He was referring specifically to the flurry of translations of philosophical writing that abounded across Europe under the Enlightenment, spreading the ideas from which the political project of a unified Europe would eventually spring centuries later. A politics of linguistic diversity, such as the one carried out by the EU under this respect, would seem like a way to guarantee the right that these ideals might come to fruition. On the other hand, one could say, and I think it's a really strong argument, that the guarantee is purely formal. There are 2,000 translators at work producing 1 million pages a year, but the Court of Justice does not publish statistics concerning the actual downloads and views of the rulings it makes available in 24 languages on its website. But they're likely rather small, especially for relatively less spoken languages. In our installation there, you will see it's a collection of some of the books of which you see the whole collection there, that gather all the rulings of the European Court of Justice published in all 24 languages. We asked the court to supply with some of these books, and we got Hungarian, we got Polish. We didn't get English, of course, because the English books always run out of print because of high demand. Everyone wants the English books. This is not true of Italian, it's not true of Latvian. One could also argue that the knowledge of English is common enough today, and more common in the future, that the considerable budget invested in translating everything into every language, it's a 1% of the European Union's budget, it's kind of a lot, could be used for more explicitly redistributive purposes. Instead, it is used to guarantee an abstract right, the possibility of exerting a right that very few people in practice need, making sure that, yeah, basic human rights, but also neoliberal deregulations can be disseminated throughout the land. In this respect, then, the constant activity of the world's biggest experiment in multilingualism would amount to little more than a ritual celebration of European ideals. The lawyers and translators ensuring that 1 million pages get published each year in 24 languages would be just producing a modern version of the Vestal priestesses, the women that, in Roman religion, were required to be locked in a temple for their whole life in order to keep a sacred flame from dying out. But the flame could die out, and I would like to finish this short talk by quoting alt-right strategist Steve Bannon, who, after spending months consulting for Orbán, for Salvini, for Le Pen, and other European formations ascribable to the xenophobe right, recently claimed that, very recently, like 4 days ago, the fight right now in the EU is between those who look at the nation-state as something to be overcome by the Union, and the others who look at the nation-state as something to be nurtured and cherished. Ultimately, then, one's judgment of this radical experiment in multilingualism might depend on one's judgment of Europe, which in turn is very problematic and depends on nationality and political perspective. Of course, a supposed European identity is largely a myth, coalesced around the need for frictionless commerce. But myths can be powerful. A side effect of the need for frictionless commerce has been, at least in Europe, a long-lasting peace between the very nation-states that Bannon and Orbán and Salvini and Le Pen wish to nurture. And as Italians, seeing their own country governed by, well, you know what it's governed by, it is our strong belief as authors of this film essay that the flame must be kept ablaze, even if it's just a ritual. Thank you very much.
So we still have 2 clips to show. And as the research of Giulia Bruno was one of the inspiration for our common projects, since 5 years she's working on a film project on artificial language and universal language that I'm also helping to co-produce. We would like to ask her to present some excerpts of her ongoing work.
Thanks, Armin. And I would like to thank also Cathy Simon, which was helping a lot in the whole working process of production. My previous research was starting from precise issues in connection with language, and in installation presented at AKV, we touched some aspect, but I'm working also on other several research fields. And I would like to share a little bit of some with you. One is language as technology. Which kind of power is carried by who on a specific technology? Which are the dominance relation or the dominance hierarchy in that? Can we live without internet? Can we live without technology? I would like to show a clip by Hubert de Vonisch, which is a Jamaican linguist, expert in Jamaican Creole, that I met in Kingston, in Jamaica.
What we're dealing with here is the technologizing of language. That in all human societies, we all spoke. What happens, however, is that in the development of human societies, take Europe as an example, you would have had oral, back to the Greeks, oral performances, performers like Homer, the mythical Homer, who was supposed to be blind and sang to a lute, and he, they produced the Odyssey and the Iliad and so on. Now, later on, long after, these oral performances that had been propagated by oral poets and performers became works of literature when writing was developed, or when writing was introduced. Now, writing is is a form of technology. What it does is to take the spoken word, freeze it, put it in a physical space, and you can then now preserve it for posterity if it's on an immovable object, or if it's on a movable object, you can take that movable object and send that message to somebody else. And I don't have to be physically present. That is the technology of writing. Writing is a technology. And then, in the 15th century in Europe, when the printing press was invented, you had there was technologizing of the technology, where I've got this wonderful technology that allows me to write language, or freeze language in space and time, and move it around. And then now I have the chance to produce thousands of copies of the same thing So I don't know if I want to make a copy, you have to write it over and over again. But I write it once, and then I have an industrial plant that just simply repeats by stamping paper all the time, over and over and over again.
Then I was concentrating the language of economics. And during the 50s, 60s, English was not diffused. And how to arrive to the East was my question, which was the importance of the language in the role of selling commercial goods. I found that Fiat, an Italian car labels company, was using Esperanto for arriving to the east side of Europe and even in China, in Asia. Fiat was using Esperanto for selling abroad the products, for spreading technical manuals, information, using only one booklet. And I found an incredible archive, thanks to the Archivio Nazionale Cinema d'Impresa di Ivrea, done by Fiat in Esperanto, with music by Ennio Morricone.
La 112 Queen estas elektita inter la prototipoj Fiat por produktadi aŭton je 1600 kubaj centimetroj kun altaj laborkapabloj.
Esperanto.
Tiu elekto celis realigi veturilon kompletan laŭ vidpunktoj de efiko, komforto, sekureco.
Kaj nun mi provos deklivon 50% krutan. Tiu ĉi tereno estas preparita por provi milita in veturiloj. Tial mi opinias ke neniu kliento devos alfronti similan supreniron per la 115.
Testo nomita stirpado ebligas ekzakte kontroli la vojaderon kaj la streĉojn sur la stirilo al pendigoj kaj stirtangoj.
And then the other topic was social language justice. Language is creating dependency. The Cold War, especially in the 50s and 60s, placed severe limitations on the natural development of Esperanto, because on both sides it was feared that Esperanto might facilitate contact with the enemy and become a means of propaganda. However, from the 70s, the Esperanto experienced a new phase of revival and was spread also even in Iran. And so I met Humphrey Tonkin, and this is it is in his house in Hertford. He's a professor and president of the University of Hertford.
If you look at the process of decolonization that took place in the beginning in the 1950s, well, in the 1940s actually, and running through until the 70s or so, if you look at that process, there's a really important lesson to be learned there. And this may seem like an odd analogy, but I'll use it anyway. When we set up a system of technology in the developing world, we tended to set it up in terms of the great empires. So the British went to what was then the Gold Coast, is now Ghana, and they laid down a railway system. The railway system that they laid down was dependent on spare parts that were manufactured in Britain. So that even after Ghana became independent, it was obliged to buy the spare parts for its railway from Britain. In the same way, the British supported the spread of English, and English gets its spare parts from Britain and from the United States. So language in that sense is a kind of intangible technology, if you will. So it's a way actually of bringing about connections, bonds, indebtedness even, among people, in effect. So that was going on in all parts of the world, with the result that the major languages, particularly English and French in this context, the major languages actually controlled the process. And nobody actually stopped, any more than they do today about many things. Nobody actually stopped and said, is this fair? Is this just? Is this the right way of doing things? Is creating dependency a basic good? Or is it something that should be resisted? People never really asked those questions, any more than they ask those questions about 101 things today. We very seldom act on the idea of social justice. We talk about it a lot, but we don't really act on it terribly much. And the same is true with language.
Thank you.